Let's talk about jury selection. I know it's been chatted over quite a bit, but I did want to ask you specifically about this angle. There are two lawyers that are on this jury. Your thoughts about whether or not that was smart to seat two jurors? And let me be clear, two lawyers on this jury. And let me be clear, they are corporate lawyers, et cetera, but your thoughts?
Yeah, so first of all, it's great to be with you, Katie, on a Saturday. I have a particularly strong view about lawyers. When I was U.S. attorney and people would come in the office and talk about the kind of jury that they had seated, when I heard there was a lawyer or, God forbid, more than one lawyer on the jury, I became concerned. And, maybe those concerns are a little bit overblown, but my view is it's not that a lawyer will be pro-defense or pro-prosecution, depending on the facts of the case. It's that I have an aversion to having on the jury somebody who has more influence than anyone else. And the worry would be that if a lawyer is not on your side, that's a problem, because it might be the case that other jurors would defer to that lawyer's knowledge and understanding, even if the person is not involved in criminal law. They went to law school, they took substantive criminal law, they took criminal procedure, and it may be the case that they're deferred to. Now, the fact that you have two may mean that they would balance each other out, and no particular lawyer on the jury would predominate, but I don't love it. I don't know that you love it either, probably.
I'm on the fence, but I get your point that it's net zero, maybe. I guess it just depends on who has the bigger personality. Let's talk about opening statements. We're all looking forward to see what happens on Monday. My question to you is very specific. What kind of themes are you going to be looking for from the prosecution and from the defense in their openings?
Well, so that's an interesting question. I think we had a preview of the theme from the defense. From the prosecution, and that is the emphasis on how this is a serious and important case. You don't have to prove motive in most criminal cases. You don't have to emphasize why a case is important, why it's important to the state, to the country, to the rule of law, and to the doing of justice. But I think that the DA's office feels some obligation and need to emphasize that, which is why they don't like it being called a hush money case. They don't like it being called, a simple documents case, but in fact an election interference case. So I think you're going to hear them sound over and over again the important theme of why this is significant and why the jury should care and why this was a serious crime.
And in terms of witnesses, we did hear from the DA's office at the close of business on Friday that they should be able to put on a witness, that they won't actually get to cross-examination on Monday, considering it's a truncated day. It ends at 2. If you were prosecuting this case, Preet, who would be your first witness and the last witness you would put on in this case?
So I'll answer it by saying who I think it should not be and won't be. It should not be Michael Cohen. I think you want to have your, difficult and controversial and potentially not smooth witnesses. And I think Michael Cohen falls into all those categories, not at the start. So it could be somebody who can give an overview of what the case is about, and those details get filled in along the way. And then you always want to end strong. So again, not Michael Cohen, not a difficult and thorny witness, but a general overall summary witness if you can at the start, and then you tuck those cooperating witnesses somewhere in the middle.
Talking about thorny witnesses, Donald Trump declaring when he was leaving court on Friday, confirming that he will testify. He didn't make it equivocal in any way. You want to take a bet? What are we going to bet, Preet?
Yeah,
is he going to testify? You'll take which side of the bet are you going to take, though?
I'll put a lot of money on that. Now, look, he has said this before in multiple contexts, as you and I have observed over the years, beginning with the investigation by Robert Mueller. He likes to show that he's not fearful, that he's strong and aggressive, and that he can testify and prove his innocence and exonerate himself. He never ends up doing it. It's very, very rare. He did it in a civil proceeding recently. It didn't go well for him. His lawyers certainly, and I'm guessing you would agree with this, will be telling him, do not testify under any circumstances. And part of the reason for that is he subjects himself not only to withering cross-examination on the scandalous details of this payment and the relationship with Stormy Daniels and everything else, but also to cross-examination on other bad acts that he may have been committed. You made mention of the Sandoval hearing. That hasn't been decided yet. But when someone decides to testify, the judge is allowed to bring in, or can allow the prosecutors to bring in a whole host of other bad acts and salacious activities on the part of the defendant that otherwise would not be able to be brought in. And I don't think Trump would perform well in cross-examination either, in terms of his comportment and his respect for the questioners and the judge. We've already seen some of that with eye rolling. He's been admonished for that already in the courtroom. It could go even further south if we were to take the witness stand. So I don't think he's going to do it.
So, Preet, later on in the show, I am going to talk about the contempt hearing that's coming up on Tuesday. Just kind of take a deep dive in not only procedurally, but substantively what to expect. But I'm going to ask you this, because you've been in New York for a long time in that judicial system. What is an available remedy for Judge Merchan that's more than just a $1,000 fine for each violation of that gag order?
I mean, look, the most serious penalty available within the discretion of the judge is to put the defendant, in this case Donald Trump, behind bars for a period of time. I think for all the reasons that people might guess, it's an extreme thing to do in a case like this, where you have somebody who already has complained that he's not able to campaign, he's not able to be on the campaign trail, he's not able to go do other things, he can't go watch and participate in other legal proceedings that relate to him, including in this United States Supreme Court. I think he's going to try really hard, the judge, to escalate the penalty up to, but not including, putting him behind bars. But that remains an option. I think that would just be, a very significant thing to do. He'll threaten it. I don't think in the immediate future that will be something he does, though.
But what about the logistics before I let you go? I'm out of time, but I have to ask. The logistics. Because people keep on saying, oh, you can't put the former president of the United States with his Secret Service detail in jail. But Preet, speak to the logistics of that, because you've had officials that have been in and out of the SDNY over the time that you were there. I mean, there is some way of being able to accommodate somebody like Donald Trump if he is incarcerated, correct?
Look, presumably, yeah. There's got to be some way to accommodate, but I've prosecuted, my office has prosecuted many high-ranking officials in office, but never someone who was a former president of the United States who had Secret Service protection. So it becomes complicated. Look, I guess another, midway point is the court could decide, as the court sometimes does, for defendants who are, pending trial, to have a form of house arrest. And in that way, the person can't leave their home, can retain the Secret Service protection, and there's some punishment there, and doesn't allow, Mr. Trump to go and do the other things that he wants to do in his spare time, including evenings and on weekends. But the question you asked, the answer is unclear, because it's totally unprecedented to have somebody who has, by law, Secret Service protection paid for by the taxpayers of the country. Do you put him in a cell and have Secret Service agents in an adjoining cell? Do you have them sitting outside? Does he have to forcibly waive his right to Secret Service protection? Those are complicated questions, and I think that's a reason why the judge is going to be ultimately reluctant to impose that kind of punishment.
The only thing I will say, Preet, before I say goodbye, is something is unprecedented until it's precedent, right?
That's true.
Maybe
That's true.
Judge Merchan will create precedents for a former president of the United States on Tuesday. Preet Bharara, thank you so much for joining us, especially on a Saturday. It's good to see you.
Thanks, Katie. Good to be with you.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.